Good afternoon, ladies and gentlemen. A warm welcome to you, our members, and thank you for joining us today for the CESA Practice Notes webinar. The practice notes for today's webinar is Practice Note 43, Legal Risk Management. My name is Oliver Rowe, and I'm the Contractual Affairs Manager at CESA, and I will be your facilitator for today's webinar. What are the CESA Practice Notes? In short, the CESA Practice Notes are a practical resource that helps consulting engineers in South Africa operate efficiently, ethically, and in line with industry's best practices. They are designed to improve the overall quality and consistency of work within the profession and to protect both the engineer and their clients. To access the CESA Practice Notes, please go to our website, www.cesa.co.za. Under the Guidelines tab, you will find the practice notes. This is a service for our members, and as such, it can only be accessed by our member firms. If you are from a member firm and would like access to this practice note and others, please contact Gillian, who will be happy to assist you. You can contact her at Gillian, Gillian, at cesa.co.za. I will place this in the chat during the webinar. A bit about the history of the CESA Practice Notes. They began in 1962 as advisory notes, with a name change in 2012 to Practice Notes. Over the years, they've been updated and added to, where we are now have over 100 such notes, with new notes coming in on a monthly basis. The practice notes are categorized into 6 specific areas. The 6 areas are clients and appointments, construction stage services, good business practice, legal responsibility disputes, professional conduct and development, quality and risk management. If while reading these practice notes you feel that they may need to be updated due to industry changes, please don't hesitate to email me, Oliver, that's Oliver at cesa.co.za, and I will have our professional team review the practice note. Some house rules before we introduce today's speaker. Please can I request that any questions posted into the Q&A icon found in the bottom of your screen and any comments be placed in the chat. Now let me take this opportunity to welcome our guest speaker for today's webinar. Our guest speaker is Sam Varela. Sam Varela serves as a Principal Legal Risk Advisor at Aon, South Africa, holding an LLB degree and an admitted attorney, an associate member of the IISA, that's the Insurance Institute of South Africa. Her interests lie in risk management within the professional indemnity sector, particularly concerning the built environment and medical malpractice law areas. So who and what is Aon? Aon exists to shape decisions for the better, to protect and enrich the lives of people around the world. Aon's experience, global reach, and state-of-the-art analytics means that they are better able to deliver the insight and advice that help today's companies protect and grow their business. Aon is a leading global professional service firm providing a broad range of risk, retirement, and health solutions. The key advantage is a broad view of 2 of the most important issues in our economy today, that of risk and people. At Aon, our team has deep experience across all segments of the professional and business service industry, and we partner with clients to identify and implement sophisticated risk mitigation strategies, drive growth through novel applications of data and analytics, and create sustainable people strategies that improve employees' engagement, health, and well-being. Aon provides advice on comprehensive insurance and risk management solutions for every professional, personal, and business need, from specific broker solutions and professional liability risk to personal and business assets and cyber liability. And so without any further ado, let me hand over to Sam to start our webinar this afternoon. Sam, over to you.
Good afternoon to everyone, and thank you, Oliver, for that introduction. I hope everyone's got a nice coffee with them and you're ready to spend some time with me I'm going to take, a little bit of the afternoon to discuss with you something that's very, very close to my heart and something that I'm very passionate about and something that we work on every single day with our clients. And that really is this concept of risk management. This isn't a crash course on risk management, so it is a very, very broad field. And there are many aspects to consider when looking at your own risk management or your business's risk management. I've just highlighted some of the key aspects of the practice note that we're discussing today. After the presentation's done in some time, we're going to send out an email that will have access to my contact details and some more of the services that we offer, the nature of the services that we offer. So if you ever have any questions or something that you'd like to discuss, or you want to inquire a little bit more about the risk management services that we offer at Aon, together with our professional indemnity offering, you're welcome to contact me through there. So my details will all be there and my team's details will all be there. Okay, so without any further ado, I'm going to jump right into our topic for today. Again, if there's any Q&A afterwards, please can we just ask that you save them for the end of the session, and then we'll address them there. That's really one of my favorite parts of the presentation, where we get to interact and learn from each other. So please save those and please stay on if you can and you have a little bit of time afterwards. So to jump right into it, on today's agenda, I'm going to be discussing this concept of what we call professional indemnity. I'm going to speak a little bit about some common causes of claims, and I'm also going to take us through some common topics and concerns around contracting or contract documentation. While I'm going through the session, I'm not going to have a look at the chat. So please can I just ask that if there is anything urgent, that you raise your hand and the facilitators will contact me and get hold of me, and then any questions we'll take after the session. Okay, so let's talk a little bit about what we call professional liability. Now, essentially, the concept of professional liability is centered around what we call a duty of care. And that duty of care is what a professional owes to not only their paying clients, but also to the community at large. So if we think of, for example, we're assisting with the design of a bridge or a road, and something goes wrong, it's not only the paying client that has the ability to sue the professional, and that professional obligation and duty of care is owed to. And I'm going to speak a little bit later on about that and about when you are providing services for no fee, or in law, what we call pro bono services, and also where there's no contract in place, which is very, very important. I have a nice slide on that I'm going to take us through. Okay, so again, this is not an all-inclusive list. These are just some of the topics from the practice note that I've taken out that I think are very important to discuss and deserve some time that I'm going to spend on each one. And the first one that I have there is the risks around contracting. And really, in the day-to-day running of the risk management solution and offering that we provide, we pick up all the time that there is so much obligation and responsibility placed on signing a formal contract document with a client. And many, many people don't realize the implications of signing that document and how onerous that document might, in fact, actually be, and the implications of signing it. Even if it is prejudicial to you and you sign that document, you then accept the terms and conditions of that, provided all the conditions of contract, of meeting a valid contract, are met. So that essentially comes down to consensus. Do the parties agree to what they are signing? And is that contract being validly concluded? Is there a meeting of the minds amongst the parties? There are very few defenses to deeming that contract not valid. One of those defenses being duress. So if you say that you were placed under duress to sign the contract, for example, somebody threatens your life and says, if you don't sign that document, there's going to be dire consequences for that. That is an example of duress. Somebody saying, or a client saying to you that they're not going to sign a contract or they're not going to pay you because you haven't signed a contract is not duress. That is commercial pressure. And that's very, very different. So it's very, very hard to make an allegation that a contract is not valid just because it's onerous and just because you didn't know and understand the terms and conditions of signing that agreement. Again, as long as those formalities around what constitutes a valid contract are met, and there is a consensus among the parties around that, and you have put pen to paper and you have signed that document, then that is technically a legally binding document, and it can and most likely will be enforced. Those allegations around whether or not that is a valid contract, again, are incredibly difficult to prove. So really my message here is, before signing any contract, make sure you know and understand the terms and conditions that are contained in that document, number one. And if you don't, that you are seeking out the professional advice of somebody who can assist you with that. My team specialize in providing the risk management service. So we don't give commercial legal advice. There are attorneys that are able to do that. We focus on the risk management around the insurability of that work that you are signing off on, and what are some of the clauses that you could potentially be signing that could prejudice your insurance policy. Okay, then the next one that I want to chat a little bit about is doing work that goes beyond the scope of an engineer or outside of your discipline that you've agreed to. Now, there's a couple of things under that that are very relevant. For example, if you are signing off on work that is meant to be done by a contractor, or you are accepting responsibility for a contractor who is physically doing construction services or construction type work, your professional indemnity policy is not designed to cover that. There are policies that we offer at Aon, contractors or risk, etc., that do cover those risks, but they require, the suitable qualification to be able to do that, and also, the expertise required to do that. So if you are signing work that goes beyond your scope, that you are, first of all, either not being paid for, that you are not suitably qualified to do, and that you're not correctly or adequately insured for, that poses a lot of risks in terms of claims. And the next one that I've got there is what we call the appointment as a principal agent. Now, traditionally, we might see on a project that an architect is being appointed as a principal agent, but there's no general rule of thumb around that. So if you are being asked to come in and be or act as the principal agent, and you are signing off for and on behalf of your client, that from a contractual perspective can be very, very onerous. So be careful of that, and be mindful of in what capacity you are signing those documents. Essentially, if you are acting as the principal agent, you are acting as the client's trusted advisor. And the client is meant to be signing those documents on their own behalf, as the appointing party of those third parties. You are acting as the trusted advisor to facilitate that process, not necessarily step into the shoes of the client. So be careful of how you are signing that and what mandate you are signing, and that you are not essentially stepping into the shoes of the consultant who is then appointing the other parties, unless that is your intention. And then knowing the responsibility that comes with that, and the checks and balances that need to be in place from a risk management perspective to navigate that. And then the next one I've got there is what we call the signing of onerous contracts. Now, I could speak for days on this, on the type of clauses that could be in a contract that could prejudice you. And I've just highlighted a couple of the ones that, we pick up in the industry that we know are just not meant to be in professional services agreements. They don't belong there, and they do have the potential to impact the insurance policy. And the first one that I want to speak about there is what we call a fit for purpose clause. Essentially, this clause is derived out of what we know as the UK Sale of Goods Act. And my key word and my emphasis there is on the word goods. Engineers are not in the business of providing goods. They're in the business of providing professional services. So it just does not belong in a professional services agreement. It is very, very difficult because services are always unique in their nature and generally uniquely designed for their purposes, that it would be onerous to sort of slot those clauses in there. Similarly, and for the same reason, a warranty, it's very easy to warrant a good. It's very, very difficult to warrant a service and a guarantee. And that may be very onerous and prejudicial to the insurance policy, because one of the very important and essential key legs of the test that need to be proven is negligence in order for the policy to be triggered and then to respond. And when you are warranting something, you are essentially saying that you are putting up to say that, or putting up the promise that something will perform in a certain way. And if it does not, there will then be automatic liability. It is a contractual undertaking that may potentially be very onerous. And if you are taking that leg of the test away to prove liability, that is an essential leg to ensure that the policy is triggered and then can respond. So you are then removing that leg of the test. And, in order for fault to be proven, that process has to then happen and unfold. And it's very difficult where there are contractual undertakings. Pure breach of contract, warranties and guarantees, if that is the sole cause of the liability and fault is not tested, not alleged, not tested, and not proven, the policy essentially can't respond to that. So those are some examples of clauses just to be careful of and be mindful of how they're worded and, what they are designed for, where they belong and where they don't belong. I always like to use the example of, you don't take a lease agreement and change the wording of the lease agreement and try and use it to sell a house. It's just not designed for those purposes. We have sale agreements, that are designed for that purpose and must be used for the correct purpose. To go and try and reword that lease agreement to make it applicable to the sale of a house, it just doesn't need to be done, and it can be very, very onerous. Okay. So just on to the next slide, liability claims. And again, I haven't given all of the sections of liability claims, but I just want to discuss, some of the topics underneath these. And remember, earlier on, I spoke a little bit about what we call pro bono services. And that really is when you're providing services for no fee. Now, essentially there, what's important is, just because you are not charging for a service in no way means that you are then not liable for the services that you provide. So even if you are doing a favor, community service work, or you're assisting friends or family, if you are negligent in giving that advice and the court finds that it was reasonable for the person who relied on you to rely on you because you held yourself out to be a professional, then essentially, liability can attach to that. And it may not necessarily be the person who asked you to do the favor. It may very well be a third party who's then injured as a result or suffers a loss as a result of those services. So just because there's no fee does not mean there's no liability. And even more importantly, there is sometimes when you're doing favors, there's just no contract that's being signed because one assumes there's no liability that's attaching to that work, which is absolutely also not true. So even if you are doing a favor for someone, I would always suggest that you consider consulting one of the standard form documents just to cover your liability. So CESA offer a great standard form. They have a suite of documents, a consulting services agreement and the sub-consulting services agreement that has the limitation of liability. You don't have to go out and redraft that document. There are many standard forms available that cater for these exact purposes. So I would really consider that if you are doing work for no fee, and just be mindful of the fact that you can definitely still be sued. And then just a quick discussion on the law of delict. And I have this in here because we often speak about, the onerous obligation of contracts and contract liability when you're signing a formal contract with a client. But essentially, even if you don't sign a contract with someone, again, that does not mean that you cannot be sued, and that does not mean that you cannot be held liable. Ultimately, what could happen is the third party who suffers the loss could come in and sue you in terms of what we call the law of delict. Now, I'm not going to try and give you a crash course on the law of delict. it is a very, very long and complicated course in the LLB degree. But essentially, my message here around the law of delict is that even if you don't have a contract, you can absolutely be sued, you can absolutely be held liable. It's not the easiest route to prove liability, but it does exist. And if a third party is suffering a loss, or they've suffered a loss, and they can prove that you were the cause of that, and they prove all of those elements of the delict, then absolutely, that liability could attach to you. Okay. The next one is clarity around scope. And I absolutely just cannot stress the importance of clarifying your scope of services with your client. Now, often this goes through a process where it's changing throughout the lifespan of the project. And even at the tender stage, the parties are negotiating around, fees and what they are prepared to provide, what they are able to provide, what their expertise is, how they are going to provide it. Are they going to subcontract some of the work out? Are they going to do it in-house? What are the plans around that? And I just can't stress enough the importance of that being clearly documented, making sure that both parties are on the same page around what is expected of me and what I am agreeing to. And if that is changing throughout the lifespan of the project, from tender stage up until sign-off and afterwards too, if there's any additional work that's being expected or taken away from you that you are now no longer being asked to do, that is clearly documented, and that you can find those documents if something does go wrong. If there is vagueness around your appointment and you're not sure why they are changing something, or what is being expected of you, what extent you're being expected to perform, a service or a function, it's important to obtain clarity around that. And again, keep backed up documents around that. To rely on an unwarranted assumption can be very onerous and very dangerous if there is a claim. So I always say confirm everything that you can and avoid assumptions, and get those that scope of services clearly defined in writing, so that you can refer back to that and that you can reference that if there is a claim. Okay, so just some more important considerations to remember. The duty of care in terms of professional liability is owed essentially to your paying clients as well as third parties. So it's not only being owed to the person who pays you or mandates you to undertake the work. It is also owed to those third parties who may suffer as a result of your errors and omissions. It is absolutely essential, and I really cannot stress enough how important making sure that there is consensus between the parties. There is a meeting of the minds. And that generally will happen at tender or pre-tender stage, where the parties will either get together and sit around a table and discuss the scope of services, and you will present what your fee for that is going to be, and there will be a discussion around that, and you will agree or not agree to certain services for whatever reason. Either that's not within your discipline or your expertise, and you believe somebody else should be appointed. And then very, very importantly, making sure that that is correctly and adequately insured, and that those services are properly disclosed to your broker. We have a team of expert brokers at Aon that can assist you with that. You come to us, you tell us what you do, and we will assist you in placing those policies. So it's so important to have clarity around what you are being appointed to do, the type of services that you're being appointed to do, and then having that relationship and that conversation with your broker to make sure that the cover is being correctly placed. And then again, it's not on the slide, but another one from me is just ensuring that your contract documentation is in order, making sure that you are signing sound quality documents that protect you, number one, and that you are backing up and keeping. If you don't have access to that document when there's a claim, it's very, very difficult to go back and try and remember what was discussed and what was agreed. So I just can't stress enough the importance of good, sound record keeping. If there is emails or minutes of meetings back and forth amongst the parties, back that up and make sure that you can actually go back to that and refer to that if there is ever a dispute around what the parties were agreeing to. And then just a last note on professional liability. I think what's so important to remember there is the question is going to be asked, did the professional provide advice? Did they hold themselves out to be an expert or professional in their field? And was it reasonable for the person who suffered the loss or the harm to have relied on that professional advice? If you hold yourself out in that professional capacity and something does go wrong, the court will ask those questions. Was it reasonable for that person who relied on your advice to have relied on that advice? And why did they rely on that advice? So it's not going to come down to were you paid for the services and was there a contract in place? That is not used in the test for negligence. And did your conduct fall short of what is expected of the reasonable professional in a similar position? Those are the types of questions that will be asked. Okay, so just a quick section again on contract documentation. And again, this just comes back to the key focus that I have on keeping and maintaining accurate and detailed records. Essentially, if there is a claim, that could then be your evidence and will be your only evidence and proof of what happened. So it's so important to keep accurate and detailed records because essentially that's going to serve as the primary evidence to support your claim. And really to put you and place you in the absolute most defendable position possible. You must be able to prove that and you must be able to provide that. And it's very, very difficult to do that when there just is no contract or sound documentation. That doesn't only refer to the contract documentation. It could be minutes of meetings or discussions that were had that have been saved and documented and recorded, etc. I'm not talking about voice recordings. I mean minutes of meetings there. And then what's so important is obviously to try and avoid the dispute if you can. Clear documentation might actually help you prevent a misunderstanding on a project with your stakeholders. So making sure that these issues and these matters are all being ironed out before you commence with the services. And later on, during the lifespan of the project or even before you start providing services, if a disagreement or a dispute arises, then you have backed up records and you have your minutes of meetings, you have your signed off approvals, and you can clarify those, and it's easier to sort of mitigate that and to manage that and sort of minimize the conflict that could potentially, ensue. Now, good record keeping really is essential for engineering claims for many critical reasons. And just some examples of those are like minutes of meetings, again, correspondence, your design technical documentation, your contracts and scope or mandate, very, very important. If there are being counter offers made, what was agreed, what was signed off on, and what was the final consensus. And then hearsay evidence, for the most part, is not admissible. Now, I'll spend a little bit of time speaking about hearsay evidence because I know it's an interesting topic. But essentially what I mean by this is if there is a matter and the matter has to be determined or decided upon, the parties need to present evidence. And that evidence has to be then tested. So if we have a contract, for example, that both parties have signed, there's no dispute as to the fact that they signed it, there's a consensus and there's a meeting of the minds. There's no dispute around that evidence then being used. But if we are going to rely on conversations that happened and those parties are not available to testify or to be questioned or cross-examined, essentially hearsay evidence is not admissible. And it won't be admitted to the court and it technically then can't be used. There are very, very extreme cases where the courts may allow for that, for example, if it's in the best interest of justice, but I would not rely on that. You need to be able to prove your matter, and the best way to do that is to have sound contract documentation in place and proof of what happened and consensus around what happened. Okay. And that is all she wrote.
Thanks very much, Sam. Appreciate it. I've been monitoring the questions and answers. Right, we've got two questions. I'm going to let George Miller talk first. George, feel free to go for it if I've done it correctly.
Okay, thank you, Oliver. Hopefully you can hear me.
Yes, we can.
Yes.
Thank you. I think I just want to thank the speaker for Sam for that presentation. It was very good. I think just
Thanks.
one comment that she made was around the definition of professional services, sometimes by clients as goods and services. I think what we are finding is a lot of public clients, are inserting in their contract documents, especially at tender stage, those terms, the goods and services. And I think it's unfortunately because supply chain management, they're so used to just buying materials as opposed to professional services. So obviously, I think as a consultant, you try and read through that when it comes to contract signing stage. But there is, unfortunately, I think it's a tendency, and I'm wondering whether AON and other insurance, companies, when you deal with government and when you get on other platforms, are you trying to lobby, the public sector to making them aware that this is an issue? Unfortunately, I think a lot of it has to do with capacity and training. But it's also easy way out for supply managers sometimes not to draw up and prepare new contracts, and they often do use these contracts that are more suited to the buying of products rather than services. And I'm wondering if there's a way around it. Obviously, as a consultant, you can object, you can make them aware and say, look, we think this contract is not suited. But often if you go down that road, you are forced to giving up that contract, and you cannot then sign that contract, and you have to walk away from that job. And as we know, in an economic difficult climate, it's not always able to do that. So what would be your advice in that regard? Thanks, Sam.
It's a very good question, and it's something that comes up all the time. It's something that I see all the time, where a professional services agreement is presented as a professional services agreement when we look at it and it just speaks to contractors and provision of goods and not services. And again, I'm going to use that example of when you're purchasing a house, you don't use a lease agreement. We can try and change that agreement, and we can change the wording, and we can change the definitions, but at the end of the day, it has to meet the purposes that it's designed to meet, and it needs to fulfill, sort of those gaps, and it needs to fulfill the services and the functions that it's meant to fulfill. That's why we're using the contract documentation. So, we definitely do try and educate our clients around where those errors are when we look at those documents. But it is very, very difficult when, you sort of exactly what you're saying. You're faced with the challenge that, you're being presented with these documents. And if you go back and you say, no, I can't sign this, this isn't relevant to me, that you then just lose the work. And the danger in doing that is, or the danger in signing those documents is, if you sign a document that's not applicable to you, it's very, very difficult to argue around why you signed it if it wasn't applicable to you, because technically you're signing it and you're agreeing to it and you're saying it is applicable to me. So you are then bound by the terms and conditions and provisions of those contracts. And technically speaking, the court is bound to uphold that contract. So if there are things in there that just are not relevant to you at all and you're signing them, it's going to be a challenge and potentially an expensive battle to fight in court why you signed that document that doesn't apply to you. My suggestion to the problem is always consider standard form agreements. The clients do not have to go and redraft a document. They don't have to pay an attorney to go and recreate a document unless they want to and they want their own standard form. But often it's a case of the consultant going back and saying, you've presented me with a contractor document. Please, can I have a copy of your consultancy agreement? And then they do receive that, because often the bigger clients do have a consultancy services agreement. And in my experience, when that conversation is had with the client to say, you've given me the wrong document, this does not apply to me, this does not apply to professional services, it doesn't serve any of us in this relationship if we sign this document, because it's going to be difficult, number one, to enforce, and it's not practical. So in order for us to regulate this relationship, let's just sign the right document. And there are many standard form documents, internationally drafted documents like FIDIC, There's the CESA standard form, the CESA suite, back-to-back suite of documents. There's the PROXA. There's many documents that one can consider. So there's options available to both parties. They just have to go and purchase those documents. So very, very good point, and a very, very common problem that we are picking up.
Thanks, Sam. Thanks, George. I appreciate that. And I think, Sam, just from CESA's side, just to obviously stress that CESA does have the forms of agreement, the professional services agreement and that type of stuff. And I think it's important that people are aware of those as a standard document that they can use in their various contracts. So thanks for that. I'm going to go and ask Ditelo, I think that's how you pronounce it, just allow him the opportunity to speak, and we can take it from there. Let me just see if I can unmute him. All right, he's not wanting to unmute.
Okay.
Oh, there he is. Ditelo, please go ahead. Ditelo, you are unmuted. You can speak. Okay, Sam, while we're just working on that side, there has been a couple of questions that have come through.
Okay.
One came from Peter Radomir. He says, meeting notes versus minuting recording. And he gives a little bit of an explanation. It says, when there is a dispute where something is signed, something in signed minutes was implemented, but later identified the meeting recording was different than what was minuted, what will have the biggest weight?
Okay, so look, technically it's going to come down to consensus and what the parties essentially agreed to. Normally, when there's minutes of meetings that are being circulated, they're circulated to all the parties to check, to verify that that's actually what happened in the meeting. There is a bit of a new challenge where AI is being sort of used to create the minutes. There's sort of these AI assist programs on Teams and these other programs that you get that transcribe the meeting, which is great, but sometimes they don't transcribe correctly. Now, whether it was being done by an AI model or the minutes of the meeting were taken by hand and noted by someone, generally the principle is that the minutes get circulated and agreed to before they get signed off on. So that should technically be the process. You know, if there's a dispute about what was said in the meeting and what's being placed in the minutes, that dispute must be raised to say, you know, that wasn't the consensus, or that's not, you know, the way I positioned that, or whatever the case might be. So it's important to clarify if there are minutes of meetings being circulated, that you are happy with what's contained in that, and it's a true reflection of what happened. Most of the time nowadays, a lot of meetings are happening online. So those AI assist tools are being used, which can be great, but sometimes they do skip text, and sometimes they, you know, somebody's got a bad connection, they might not interpret correctly, and it's written out incorrectly, or, you know, a word is said softly and then, you know, that's just not written into the text. So just make sure that you're verifying that and there's clarity around what was said and what you actually agreed to.
Thanks, Sam. So I guess at the end of the day, it's just what the agreement between the parties is the dominant one. And I think the importance of obviously making sure you circulate your minutes so that there is consensus based on it. I mean, basically what he was saying was that if afterwards you find out that there is this difference, you know, then I guess where does it tie in? What is the main one that you should go on? You know, when we do these live recordings, I mean, that's probably more of a true reflection of what possibly the minutes would dictate. So I guess the consensus still becomes, you know, make sure your minutes go out and make sure that they're agreed upon. I know we used to have a situation where we used to sign minutes. I don't know if that's normally the case anymore, but you know, that's certainly the best way to go about it. Okay, so Ditolo is still, yeah, they're muted on their side. So I've got a couple of other questions coming through. Another one, which is very similar to what we've just been discussing, from CAD15. It says, how does WhatsApp messages get viewed in documentation evidence?
Okay, so look, technically, the purpose of WhatsApp is not designed for contracting in terms of business purposes. For me, you should not be concluding contracts or agreements over WhatsApp. That is not why that facility was designed or that service was designed. If you think of SMS messages similar to what's known as a short message service, it is designed for that purpose. I need to be on site at 10. Where can I meet you? I'll be at the bottom gate at 1. Short, to the point, and it's not concluding terms and conditions of a contract over WhatsApp. That's not to say that WhatsApp evidence can't be discoverable as evidence, but I would use the platforms that you have available from a business perspective for the purposes that they were designed. So if you are signing a contract and you are arranging contractual terms and conditions and there's counter offers happening, and that's happening over email, which is designed for that purpose, that is then being saved and stored and backed up, and you can go and reference it, etc. So it's not to say that it can't be used as evidence, but be careful for what purposes you are using it for, to try and prove your matter or to try and prove your position. If you are negotiating a contract, you are clearly defining scope of services. That should be done in terms of a formal contract.
Okay. Thanks, Sam. Dotolo, I saw you were able to unmute. Please feel free. Go ahead and ask your question.
Okay, no, thanks, Oliver. Can you hear me now?
100%.
I can.
Okay, no, thanks, Sam, for the presentation. My question is with regard to a contract. If you come into a project and you find that they've already signed a contract, but then you find some of the clauses are the way you've explained them, you need to make adjustment there too. What advice can you give in terms of approaching whoever the other partner is to the contract or party is to the contract to adjust the contract accordingly? Is there any way of better approaching the other party for an adjustment to that such a contract? Thanks.
Yeah. So the first prize would be you have to go through your contracts with a fine-tooth comb before you sign it. Because once you sign that document, then technically, as long as all of those valid conditions of a contract have been met, so you're not agreeing to do something illegal or, there's conditions to making the contract a valid contract. For example, legality, the parties were able to enter into the agreement. So certain agreements, you have to be over the age of 18. So all of those things that I'm talking about that make the contract a valid contract, because there may be defenses to why the contract is not valid. For example, the person was under the age of 18, or in the contract, they agreed to do something that was unlawful, then we could raise that as a defense. If all of those checks and balances are made and they are met, and we have what's called a validly concluded contract where there was consensus and meeting of the minds, then that is enforceable. And yes, the parties can go back and say to each other, you know what, I signed that document, but there was something in there that I'm just not happy with. Please, can we agree to an amendment? The parties can come to an agreement to do that. But if you've signed the document already and there is a meeting of the minds and all of those conditions, I only mentioned a few of the conditions that make the contract a valid contract. I mentioned some of them, there's more. But if that has all been met, technically they could say, no, I'm not agreeing to this amendment. And that would be a difficult situation to sort of argue one's way out of. So my advice is, before you sign the document, take your time, go through the document, seek out the expertise that you can to try and get assistance if you need it. If you're not comfortable looking at those documents, go and seek out advice from someone to say, you know what, there's a clause in here. I'm not sure how to change it, or if it's not in my favor, and get some advice on it before you sign it. Because once it's signed, it could be a challenge and it could be a difficult situation to sort of navigate your way out of.
I guess it's the importance of reading the small print, eh?
Yeah.
All right. Sam, there was a follow-up question with regards to the WhatsApp thing. Totolo, are you happy with your answer? You've gone quiet on us. You all good?
Oh, no, I'm fine.
Okay.
What I wanted maybe was just to say, you know what, this approach may work in terms of convincing the other party, to agree to revisit. I understand that, once you sign, but you may
Yeah.
have come to a project where already the contract is already signed in most cases, and when you come, you look at the contract and you realize, but this clause and this clause, I don't think they are fine. There's quite some risk there too, and you wanted to amend. But thanks for the advice. Appreciate it. Thanks.
Pleasure.
Thanks. Thanks, Tolo. Yeah, so Sam, as I was saying, there was a little follow-up to the WhatsApp one, and it just
Okay.
said, "Hi Sam, as a follow-up, do you have case history where WhatsApp communication was dismissed?"
I don't know any out of the top of my head, but I'm very sure there's case law where it's been used. If it's been dismissed as evidence, there must be a reason why it's been dismissed. And I don't know what those allegations are. But again, because of how popular WhatsApp is and how convenient it is, we all use WhatsApp. It's a wonderful tool. And, there's even WhatsApp business now, that's used for sort of those purposes, booking of appointments or arranging meetings or, communicating with a client that you're going to be a little bit late or for those purposes. Again, I just can't stress enough the importance of not conducting formal business contracting over WhatsApp. That is not the purposes that it's designed for. And I would be very, very careful of how you're intending to use it. Yes, if there's a conversation that's happening and there's correspondence that is happening over WhatsApp, especially if your client is in another country, etc. Then I totally understand. WhatsApp is convenient and somebody can access it and read it when they're available. I totally understand that. And we all make use of those platforms. But I'd be very careful of relying heavily on it from a contracting or business risk perspective.
Yeah, I always feel like what you're saying with regards to the WhatsApp is, we have these WhatsApp groups and that type of stuff, and really, I think you need to identify what is the purpose of that communication structure that you're setting up. Is it a social? Is it a business? What are you using it for? Because sometimes it is a bit of a gray lined area where it gets used for multiple purposes, and then I would argue, it's difficult to say, well, if you're having a social communication, yet you're also having legal communication or dealing with contracts,
Yeah.
can people actually take it seriously based on the fact that there's multiple types of communication taking place in that session? Thanks, Sam. That's great. There's a lovely one that's come through, and this might just take us through for the rest of the day. So I hope you're ready for it. It says, what legal risk could result from offering excessive discounts on engineering service fees? And
Yeah.
a follow-up question, and from the client's perspective, do they truly benefit from lower cost services?
That's just such a good question. And I can't stress enough how much this question has been a topic on the table since I joined risk management 10 years ago. It's been a concern and a consideration that I think has really plagued the industry for so many years. If I think of other industries, where and in what industry would you ever go in to see a professional or a doctor and try and negotiate the fee down? It just doesn't happen in other sectors. And I totally understand that in this sector and in this industry, it's almost expected. And it's very, very, it happens all the time. Discounting of fees is expected and it's happening. We know that it's happening. And it's very unfair to the consultant in the sense that, many consultants won't be able to get work unless they agree to this discounting of the fees. From a risk management perspective, my concern and what we know from the industry is that in order to provide the package of services at the absolute best quality possible for that price, is it possible? Is it possible to put the expertise or the years of experience, especially if it's specialty type work that requires sort of that niche specialty, is it possible to do it for a fee that is so low that it just doesn't make commercial business sense? And, your professional indemnity is based off of your fees. And if you are undercutting the fees to such an extent, and I know that it's not, anybody's fault, and that's the expectation of the industry, and you're doing it to get the work and to keep the work coming in and afloat. If that is happening, then that's not a true reflection of the amount of work that's being done. And that is a risk management concern, because then technically are insurers able to then go and, see the amount of work that's being done and what type of work is being done. And it's sort of, I know how competitive it is, and I know how difficult it is in the industry. And, I know for sure that these conversations have happened at many, many levels. And it's still happening. The request and the expectation on these professionals to undercut their fees to such an extent that on some projects, for me, they're even being expected to do the work for free, basically, is very, very difficult and very unfair. But from a risk management perspective, there's definitely a concern around that. And it is definitely telling of, the industry and what's happening in the industry and how these sort of tenders are happening. And how risky that is for a firm.
It's sure, Sam. The questions are now starting to come in. Thank you for that answer. It's always a contentious one as to discounting. There was a request where they just asked you, is it possible to just define discount? I don't know if there's a different definition from a legal term, or is it just a standard?
No, I think a discount, and I'm, this is not a legal definition. That really is just less than what you would have charged ordinarily. So you have a bill out rate per hour, and whatever's less than that. I don't think there's a legal definition for that.
Okay. All right. Okay, lovely. There's another question that's come through here. It's going back to the communication and contractual communication. It says, can one agree in the kickoff meeting with the client on what communication methods will be acceptable, like signed minutes, and not meeting recordings, WhatsApp messages will not be seen as contractual communication, etc., or must it be in the signed contract?
I think it's a very good idea to agree to how you intend on corresponding. I think that's brilliant, because that sort of sets the tone and the scene for how you want to correspond with your client. Because obviously when things get busy, the client might be overseas, or they might be very busy, and they might send you the updated version of the contract on WhatsApp, and then that phone gets stolen or goes missing, and those messages aren't being backed up. So I think it's a brilliant idea to outline from the get-go how one intends to correspond, and to sort of create that tone and that trend with the client, that all correspondence that's formal is being done on email, that you've backed that up somewhere to a server, and that any amendments to a contract are being made nice and neatly on that contract, and that essentially, and very importantly, that final version is being signed and agreed to.
Okay. Great, thank you very much. Right, another one that's come through from George again. He says, if you are facing a possible legal damage claim from the client, is your advice similar to other insurers that the consultant does not immediately try entering into negotiations with the client unless this is clearly listed as a first dispute resolution mechanism in the contract? And having sought advice from the insurer, the risk being that the consultant may inherently admit liability, which could then be used in litigation if negotiations fail.
Absolutely. Absolutely. If you have an insurance policy, your first place to go is to go and speak to your claims team, speak to your broker. Often a claim situation or a claim scenario is an incredibly stressful, and it can become very emotionally taxing on anyone, whether it be financial, or if there's been serious damage to property or to people's lives. It can be a very, very difficult time. And, claims teams are designed to deal with that, and and trained to assist in, that instance of a crisis. So it's so important to first, step one, reach out to the people that do this and that specialize in doing this, to guide you and hold your hand through that process and take you through the process of, how do you respond? And if there is going to be a settlement or negotiation that's offered, is that done in the best way possible? There's an entire there are legal formalities around settlement offers. Are they being done? Are those documents being drafted up by lawyers? Are they being signed off correctly? Is it full and final settlement? Is it with or without prejudice? So there's many, many legal terms and conditions and concepts to consider when one is considering a settlement. So for me, the professionals must be involved from the very, very beginning. And, more often than not, having the right people or the right team of experts behind one in a situation of a crisis can determine the outcome of that crisis. So having the right set of professionals or experts on board from the get-go will really determine how that plays out or how that sort of turns out in the end. And if it's managed correctly, the risk can be completely mitigated. So I would say as soon as possible, even before the client, your client complains or says that something's wrong or there's contention there, reach out to the experts first.
All right, thanks, Sam. So don't try and do it on your own. Reach out is basically what you're saying, Ham. All right, I've got another question here. In the event of an EPCM contract where the client appoints the contractor for construction, to what extent can the client hold the EPCM consultant for delays, damage, etc. by the contractor?
That will depend on what you've agreed to in the contract and how that appointment is happening. If the client is appointing the contractor directly, then that's a relationship that exists between the two of them. The question is going to come down to in what capacity were you being appointed in? Are you supervising that contractor? Are you appointing them directly? How is that relationship being managed? Or is it even the other way around? Maybe the contractor is being appointed to appoint you. And then also what you've agreed to in the contract documentation. Have you agreed to liability for delay damages on behalf of the contractor? What have you signed off on? So it's very important to make sure that you're going through that contract documentation with a very fine-tooth comb to see what checks and balances are in place.
All right, thanks, Sam. So the biggest thing here is to make sure that you understand what you are signing and what you are taking responsibility for. And I'm assuming they can contact you guys if they are in need of advice and direction. Quick plug
Absolutely.
for Aon. Quick plug.
Absolutely.
All right. So here's another question. This is quite an interesting one from Adam. What do you suggest when you have work with clients who don't have legal departments and as a result don't have a culture of signing SLAs or contracts?
Can I just ask, are you talking about your client's client? So your client doesn't have a legal team. The consultant's client doesn't have a legal team, or the consultant doesn't have a legal team?
Let me see if Adam's available to come online and he can maybe just ask that question. Adam, are you available to just provide? Oh, he's responded by saying the client.
The client. Okay. It's a tricky one. There's many consulting firms and clients who don't have their own in-house legal team to assist with these sort of negotiations or, navigating the complex legal terms of a contract or the negotiation around a contract. That is exactly why we have standard form documents. FIDIC, CESA, NEC3, all of them. PROXA. CESA's standard form is drafted in such a great way that it's simple, easy to read, and you don't have to be a lawyer to interpret those clauses. It deals with the topical issues that need to be dealt with. So the complexities are all there. Everything that needs to be in there is in there. And most importantly, it's fair to both parties. The standard form is not in favor of one or other of the parties. So it really is that line in the middle of the sand to say, this is a fair document. It protects both parties. It's not in favor of one or the other. So all of the terms and conditions in there, if I was a client, I wouldn't feel necessarily uncomfortable with signing that document. And it's not a very long-winded document, so it's not 100 pages of complex legalese. And again, if one doesn't understand or know what those terms and conditions are, there's always parties that one could reach out to, third-party, external parties that one could reach out to say, right, we just want to clarify what this means. How does this clause work? If there's a claim, how would this potentially work?
In closing, colleagues and friends of CESA, at this point we have reached the end of today's webinar, and I'd like to take this opportunity to once again thank Sam for giving of her time and for Aon and for sharing her knowledge and the thoughts with us. as well as our delegates for supporting CESA and attending our webinar. As this is our last Practice Notes webinar for 2025, I would also like to take a moment to wish you all a wonderful and safe festive season and a very happy holiday period. Thank you for your continued engagement throughout the year, and we look forward to connecting with you again in 2026. In closing, I'd like to kindly request delegates to complete the satisfaction survey that will pop up. If it doesn't pop up on your screen, it will be coming through over the next few days, and please feel free to just fill it out, and just so that we can figure out how we can improve on things. Delegates who are registered with EXA may claim a 0.15 CPD point for attending this webinar as per our webinar attendance list, and that information will go out to you. The webinar will also be available on our CETV YouTube channel. Again, thank you for your attendance and participation. Goodbye and happy holidays. Thanks, Sam. All the best.
Thanks, everyone. Thank you.
Cheers, guys. Bye. Bye.